Hello, this is Professor Orms, and welcome to Module 1, Introduction to Environmental Law and Institutions. In this first module, we're going to look at the sources of environmental law and the administrative agencies in a little bit more detail, as they play a key role in the promulgation of environmental laws and regulations and their enforcement. So part 1 is the American legal system, the sources of environmental laws. Particular context in the environmental arena dictate reactions to environmental threats. So before understanding the possible reactions to environmental harm, you must first understand our legal system. The first step in this process is understanding the origins of our laws. There are 4 sources of environmental laws. The 3 articles of the U.S. Constitution creates a federal government composed of 3 major branches. The legislative branch, created under Article 1, primarily creates laws. The executive branch, created under Article 2, primarily enforces laws, and the judicial branch, created under Article 3, primarily interprets the laws. While performing their major functions, the executive and judicial branches also create laws. And then in our 4th area, administrative agencies are the 4th source of laws, and we will look at those in more detail in Part 2. Now let's begin to look at how each branch serves as a source of law. In the legislative branch, Article 1, Section 1 of the U.S. Constitution states, "All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and the House of Representatives. Laws made by Congress are called statutes, which means that they are written down. And most environmental laws are made by Congress." In this hyperlink here, you may click on that at your leisure, and it will tell you where to find the actual laws. For example, regulations made by the EPA are codified or written down in the Code of Federal Regulations, Title 40. So we will look at that in more detail as the semester progresses.
Whew, you sure gotta climb a lot of steps to get to this Capitol building here in Washington. Well, I wonder who that sad little scrap of paper is.
I'm just a bill, yes, I'm only a bill, and I'm sitting here on Capitol Hill. Well, it's a long, long journey to the capital city. It's a long, long wait while I'm sitting in committee, but I know I'll be a law someday. At least I hope and pray that I will, but today I am still just a bill.
Gee, Bill, you certainly have a lot of patience and courage.
Well, I got this far. When I started, I wasn't even a bill. I was just an idea. Some folks back home decided they wanted a law passed, so they called their local congressman, and he said, "You're right, there ought to be a law." Then he sat down and wrote me out and introduced me to Congress, and I became a bill. And I'll remain a bill until they decide to make me a law. Just a bill, yes, I'm only a bill, and I got as far as Capitol Hill. Well, now I'm stuck in committee, and I'll sit here and wait while a few key congressmen discuss and debate whether they should let me be a law. How I hope and pray that they will, but today I am still just a bill.
Listen to those congressmen arguing. Is all that discussion and debate about you?
Yeah, I'm one of the lucky ones. Most bills never even get this far. I hope they decide to report on me favorably, otherwise I may die.
Die?
Yeah, die in committee. Oh, but it looks like I'm going to live. Now I go to the House of Representatives and they vote on me.
If they vote yes, what happens?
Then I go to the Senate and the whole thing starts all over again.
Oh, no.
Oh, yes. I'm just a bill. Yes, I'm only a bill. And if they vote for me on Capitol Hill, well, then I'm off to the White House where I'll wait in a line with a lot of other bills for the president to sign. And if he signs me, then I'll be a law. How I hope and pray that he will. But today I am still just a bill.
You mean even if the whole Congress says you should be a law, the president can still say no?
Yes, that's called a veto. If the president vetoes me, I have to go back to Congress and they vote on me again, and by that time you're so
By
old.
that time, it's very unlikely that you become a law. It's not easy to to become a law, is it?
No, but how I hope and pray that I will. But today I am still just a bill.
He signed your bill. Now you're a law.
Oh, yes.
Okay, so that was just a fun way to look at how a bill becomes a law, and the process is very complicated, but it does follow the steps as indicated there. Excuse me. Now we'll look at the judicial branch. Federal and state courts are charged by their respective constitutions to interpret the Constitution and statutes on a case-by-case basis. Once laws are made by Congress, they may lack specificity due to the fact that they could not have passed Congress if the law contained very specific provisions, such as a timeline for implementing new regulations. It is then up to the court to fill the gaps through their court decisions. These decisions then become precedent for others in that jurisdiction to follow. For example, if the Ohio Supreme Court decides a case, the precedent that they set in that case only applies to lower courts in Ohio. It doesn't apply to any other state, nor does it apply to any other federal courts. But for example, if the Fifth Circuit Court of Appeals, a federal appellate court, decides a case, then the precedent that sets only applies to district courts within that same circuit. However, when the United States Supreme Court decides a case, it then sets a precedent for all other circuit courts, all other federal district courts, and in areas of constitutionality, all state courts. One of the most well-known examples, for example, what they set is called the precedent. And one of the most well-known examples of how a precedent can be overruled, because a case of first impression creates a precedent, and then the reliance on that precedent from case to case is called stare decisis. Now, a precedent doesn't mean that it can never be overruled, and the most well-known example of that, where a precedent was overruled, was in the case of Brown v. Board of Education, where the Supreme Court, in a prior decision, Plessy v. Ferguson, stated that the state sponsored segregation with regards to public schools for whites and blacks was constitutional. But in Brown v. Board of Education, the Supreme Court struck down that prior ruling, the precedent, stating that separate but equal was on its face unconstitutional, and therefore the prior precedent no longer held and a new precedent was in place. And that's where we began the desegregation of public school systems in our country. Judges look to congressional intent when they are deciding cases based on statutory interpretation, because again, the courts may be interpreting constitutional issues, but they may also be interpreting statutory issues. So they look at congressional intent to determine what Congress intended when the law was made. If the judicial interpretation is not something that Congress likes after the fact, they still have the ability and the authority to go back and change the laws the way that they intended them to be. And in these cases, it tends to be more specific than it was in a prior ruling. The executive branch exercises direct rulemaking through its power to make treaties and issue executive orders. The executive branch includes the president's staff, and all of the heads of the executive departments, like the Secretary of State and the EPA administrator. The executive branch is influential in the rulemaking process in both the legislature and administrative agencies. The president influences Congress by proposing legislation, by publicly supporting or opposing proposed laws, and by using the veto. The president has the power, subject to the advice and consent of the Senate, to make treaties. Once a president has entered into a treaty and it has been ratified by a 2/3 majority in the Senate, a treaty becomes the law of the land based on the supremacy clause of the U.S. Constitution, and it supersedes any state law. The president also has the authority through signing statements to revise, interpret, or disregard legislative measures on national security or constitutional grounds. And now let's look at the fourth area, which are administrative agencies. Congress has delegated to these agencies the authority to make rules governing the conduct of business and labor in certain areas. And these are 5 examples of administrative agencies that currently exist in the United States that play a role in the environmental arena. Administrative agencies are less well known as a source of law But because of their substantial impact on the laws of this nation, administrative agencies are often referred to as the fourth branch of government. Let us now look at different types of laws. There are 6 different classifications of laws, and they fall into 3 categories: case versus statutory law, public versus private law, and criminal versus civil law. We'll look at each of these a little more closely. In case versus statutory laws, laws are classified as either case or statutory laws, depending on how they are made. If the judge interprets a case, then it becomes case law. If the legislators make a law, it's considered a statutory law. And statutory laws, by definition, are written down, printed type laws, such as the example I gave you in the Code of Federal Regulations, which is a compilation of federal statutes and regulations. And then we have public versus private law. Public laws are those set up to provide for the public welfare. They are generally applied by administrative agencies. These laws usually regulate classes of people or organizations. We will look very closely at public laws throughout the course of this summer. And private laws generally regulate the conduct between 2 individual parties. Private laws may sometimes be used in environmental matters. And then we have criminal versus civil law. Criminal law is made up of federal and state statutes that prohibit wrongs against the state or society in general. Conduct such as arson, rape, murder, forgery, robbery, and the illegal dumping of hazardous waste. And civil law is usually defined as a body of laws regulating relations between individuals or between individuals and corporations. The primary purpose of criminal laws in any area, not just the environmental area, are to punish offenders and to deter them and others from committing similar acts, usually through imprisonment or fines. Environmental criminal prosecutions have become much more prevalent in our society in the last 20 years. And violations of many environmental statutes constitute criminal offenses, but the same act can also give rise to both criminal and civil penalties. There has been an increase in environmental criminal prosecutions. The first major increase in the use of criminal sanctions to enforce environmental laws occurred in 1982, when the Department of Justice created a separate environmental crimes unit in its Land and Natural Resources Division, and the EPA established an Office for Criminal Investigations. In 1994, the EPA took another major step toward increasing its ability to compel observance of the law by reorganizing its enforcement and compliance program and creating the Office of Enforcement and Compliance Assurance, with an emphasis on targeting serious violations. The primary purpose, as I said, was to punish offenders and deter others from committing similar acts. For purposes of both criminal and civil litigation, a corporation can sue and be sued just as a person can. Of course, a corporation cannot be jailed. If they are convicted, they will be fined. However, officers or major players in that corporation, if they knowingly and willfully committed an act or a violation of an environmental law, then they can be sent to prison. Environmental convictions have taken on kind of a new emphasis in the last 10-15 years, as environmental prosecutions have also risen. The largest individual criminal penalties are often imposed when an act is considered a willful and knowing violation. The most publicized trend happening today in criminal actions is the increasing use of imprisonment for corporate violators, such as I just spoke about, including those who violate criminal provisions of environmental laws. The stigma associated with incarceration serves as a greater deterrent than fines that can be passed along as a cost of doing business. So now let's look individually at the 3 largest environmental convictions that are on record today. As an individual, William Fiore was convicted of deliberately piping 1.2 million gallons of toxic leachate into a river near Pittsburgh, the largest criminal penalty ever assessed against an individual, so he received 6 to 12 years imprisonment. And the largest fine against an individual was against a Wall Street trader who filled in wetlands without a permit in Florida, and he was fined with $2 million. And the largest corporate conviction involves British Petroleum and 2 of its associated companies in the Deepwater Horizon incident. And it happened when BP through its Deepwater Horizon well, released 4.9 million barrels of oil, making it the largest spill in U.S. waters. And on 4th of September of 2014, U.S. District Judge Carl Barbier ruled BP was guilty of gross negligence and willful misconduct under the Clean Water Act. He described BP's actions as reckless, while he said Transocean's and Halliburton's actions were negligent. He apportioned 67% of the blame to BP, 30% to Transocean, and 3% to Halliburton. And one thing to keep in mind here is Transocean was actually the company that was operating the well at the time of the incident. But BP, as the owner of the well, held the overall responsibility for making sure that its contractors and subcontractors operated appropriately. So what can companies do? First of all, companies can know the law. And I always encourage companies to do research, understand what all laws apply to them. And if delegation is necessary, which is often happens in businesses, either to employees or subcontractors or consultants, the company should supervise the activities to ensure compliance occurs. Because in the end, the company has the overall responsibility, as we just saw in the BP Deepwater Horizon incident. And I also encourage companies to do environmental auditing. And it's defined by the EPA as a systematic, documented, periodic, and objective review by regulated entities of facility operations and practices related to meeting environmental requirements. In some of my clients' facilities, they are required to do inspections on a regular basis. It might be daily, it might be weekly, it might be monthly, whatever the regulations require. But I do strongly encourage them as a best management practice to go above and beyond that. And if they only have to do it monthly, then maybe they should do it weekly. So problems don't build up over a period of time. And if the EPA walks in at any time and finds a violation, it doesn't matter if you did the inspection on May 1st. If they come in and everything was fine on May 1st, if they come in and find a violation on May 14th, you're still going to be hit for that violation. I also strongly encourage my clients to do environmental audits of any facilities which handle their waste streams downstream. So if a company creates some type of chemical waste, liquid chemical waste, and they send it to an incinerator or they send it to a recycler, then they should also audit that facility and any other facilities they use where their material might go. Because in an audit trail, when the EPA is looking to fine companies for the improper disposal or recycling or transportation of material, then everyone who's been involved in that company's activities, even those who are sending waste properly and legally to that company, will be held responsible as well. Okay, now let's look briefly at the litigation process and other tools for resolving environmental disputes. We have the adversarial system, which is our court system. We'll look at the primary actors, civil litigation, and alternatives to civil litigation. So the adversarial system is the court system, and jurisdiction is the power of a court to hear a case and render a decision. And in the United States, we have the federal court system, which is made up of district courts, appellate courts, as well as the Supreme Court. We have the state court system, in which we have 50 different state court systems, and they can be set up however that state determines. And you also have to look at the choice of courts. You can't just pick whatever court you need to go to. You have to determine if it has jurisdiction. This is a brief look at how the federal courts are organized in the United States, and you can look at that more closely at your leisure. So first of all, we look at subject matter jurisdiction. There are certain areas which the federal government has exclusive federal jurisdiction: admiralty, bankruptcy, copyrights, trademarks, patents, claims against the U.S. government, and claims arising under statutes, which are federal statutes. So again, we can be talking about the environmental arena here. And the areas providing for exclusive federal jurisdiction are where there are federal criminal prosecutions. And in some cases, there are concurrent jurisdiction, which means it can be heard in a federal court or in a court system. But if there is a federal question and there is diversity of citizenship, which means you're asking either a constitutional question or a question on a federal statutory area, and the citizens are from different states, then they may bring their suit in a federal court as long as they meet a minimum requirement which currently is about $75,000 as the basis of the claim. State court jurisdiction, any cases not falling under exclusive federal jurisdiction can go into the state court system. And that's where we look at a concurrent jurisdiction. So even if a federal question is what's being decided, it can still be decided in a state court system. Now, venue is separate from jurisdiction. Once it is determined which court system has the power to hear the case, the jurisdiction, venue determines which of the many trial courts in that system is appropriate. So venue is prescribed by statute in each state and is a matter of geographic location. And it's based on the residence of the defendant, the location of the property in dispute, and the location in which the incident out of which the dispute arose occurred. So an example that, if we look at a simple example, if an individual murdered someone who has been brought up on murder charges in Bibb County, which is Macon, then Bibb County would be the proper venue for that situation. But in the environmental arena and in the corporate business arena, you'll have companies that are from different counties, of course. You'll have companies from different states. You might even have a company, one is from the state of Georgia and the other company is from Canada. So you have to look at the residence of the defendant, and the defendant would be the person being charged, either in a criminal or civil, or the person in which is being sued, the defendant in a civil suit. The property that's in dispute, if there's a property involved, and the location in which the incident out of which the dispute arose occurred is considering the transaction that took place that is the basis of the lawsuit. The primary actors in this adversarial system are the attorneys, the judges, and the juries. There are alternatives to civil litigation, and these are gaining popularity as the court systems are very bogged down and don't have as many judges and people working for them as it has in the past. So the case system, the justice system has become a very slow process, and it was slow to begin with. So you can stay in litigation for 10, 15 years. The alternatives, arbitration is the resolution of dispute by a neutral third party outside the judicial setting. It's one of the most well-known alternatives to litigation, although it is not the form most commonly used to resolve environmental matters. So it is used a lot in business settings, but not necessarily that much in environmental settings. And mediation differs from arbitration and litigation in that the mediator makes no final decision themselves. The mediator is simply a facilitator of communication between the disputing parties. In arbitration, you might have a contractual situation between two companies that state that the arbitration is binding, which means you cannot appeal the decision to litigation to a court system following the decision. And in some cases, the arbitration is not binding, or there are laws in place which do not allow arbitration to be binding, such as in employment matters. Okay, so let's look at a few federal principles which regulate the environmental arena. Federal preemption. The supremacy clause is the basis for the doctrine of federal preemption, and this doctrine is used to strike down a state law that does not directly conflict with the federal law, but attempts to regulate an area in which federal legislation is so pervasive that it is evident that Congress wanted only federal regulation in that area. It's often said in these cases, federal law preempts this field. This is important to understand in the environmental field, because if Congress passes a law and an administrative agency promulgates regulations to implement that law, then a state cannot choose to not regulate that area, or a state cannot choose to regulate that area less stringently than the federal government has. And I deal with this quite a bit. For example, the federal government has passed the Toxic Substances Control Act. They've delegated authority to the Environmental Protection Agency to promulgate regulations regarding how PCBs, or polychlorinated biphenyls, are regulated, and the federal government regulates them at 3 different levels. Less than 50 parts per million, which means parts per million within through like a laboratory test, 50 to 499 parts per million, and 500 and above parts per million. So that's how the federal government has regulated that. So a state can't come in and say, Well, we are going to not regulate PCBs in our state until they reach 5,000 parts per million. Everything else is considered non-hazardous. The states aren't allowed to do that. But what the states are allowed to do is regulate those items more stringently than the federal government. So if you remember, I just talked about the government regulates them at less than 50, 50 to 499, and 500 and above. In the state of California, they regulate it at, instead of less than 50, they regulate it at less than 2 parts per million. So they regulate it more stringently. And in the state of New York, another area where there are strong environmental regulations, they regulate PCBs at less than 5 parts per million. So again, more stringently than the federal government. But you're not allowed to regulate it less stringently than the federal government. The next area is the Commerce Clause. And the Commerce Clause provides the authority for Congress to pass most of its federal environmental regulations. This clause empowers the legislature to regulate commerce with foreign nations and among the several states and with the Indian tribes. So among the several states is that important part. And depending on the ideological makeup of the Supreme Court, interpretations of the specific boundaries of this clause vary from case to case. So we have seen many cases go through the Supreme Court over the years which interpret the Commerce Clause and various laws and regulations that Congress has set forth. But next we're going into Part 2, Administrative Law and its impact on the environment. So we've talked about the 4 sources of law, and now we'll turn specifically to the administrative area, as it will be the area of laws that we look at more closely throughout the semester. In 4 areas: creation, functions, limitations, and important agencies affecting the environment. So Congress creates most federal agencies through statutes called enabling legislation, but presidents can also create agencies through executive orders and reorganization plans. The EPA was created by a presidential executive order, the EPA being the Environmental Protection Agency. Many people attribute the downfall of the U.S. industrial prowess to the burden of environmental regulations that came out in the 70s and 80s, but then they are confounded by the fact that a Republican president, supposedly a pro-business person, Richard Nixon, created the EPA. The administrative agencies have 3 primary functions: rulemaking, adjudication of cases before administrative law judges, and various administrative activities that help them carry out their rulemaking and enforcement. So if we look specifically at rulemaking, administrative agencies are granted authority to perform the legislative function of making rules or regulations by the enabling act or statutes such as the Clean Air Act that bring them into existence. If the enabling act does not provide the procedures for implementing the rulemaking, one of the 3 alternative methods are used, and they are informal, formal, and hybrid. But there is also rulemaking that is exempted, but there are 3 primary ways to make rules. The informal is the primary method of rulemaking and is referred to as notice and comment. It's governed by the Administrative Procedures Act. They must publish the proposed rule in the Federal Register along with the explanation for their legal authority for issuing the rule and how one can participate in the process. The public are allowed to submit written comments. They may contain data, arguments, or other information the person believes might influence the agency's decision. They can hold hearings, and it has the discretion to receive oral testimony if it wishes to do so. And then the agency will publish the final rule with the statement of its basis and purpose in the Federal Register. And the publication includes the date on which the rule will become effective, and it must be at least 30 days following publication. The informal process is also governed by the Administrative Procedures Act, and it's a formal rulemaking required when enabling statute or other legislation requires that all regulation or rules are enacted by an agency as part of a formal hearing process that includes a complete transcript. So as you notice in informal, whether they have oral testimony or hearing was optional, but in the formal process, this is required. Again, it's published in the proposed rule is published in the Federal Register. There's a formal public hearing. The transcript is made available to the public. Now those transcripts are put online immediately following the public hearing. The agency publishes the final rule with the statements of its basis and purpose in the Federal Register, and again includes the date when the rule becomes effective, at least 30 days following publication. Hybrid is the combination of the formal and informal, and that's what you tend to see quite often these days. The exempted process does not allow public involvement. The Administrative Procedure Act exempts public rulemaking with regard to military or foreign affairs and agency management or personnel. And exemptions are also granted for rulemaking proceedings related to public property, loans, grants, benefits, or contracts of an agency. So basically what the exempted process is saying is that it doesn't have to go through a formal or informal or hybrid process. There are many problems associated with rulemaking, one of them being that the process is long and laborious and may still involve lawsuits after the rule takes effect, even though the public was invited to be a part of the process. I've been involved in the rulemaking process for nearly 30 years and have yet to see it improve. And the process is also very costly. For example, when the EPA puts out a proposed rule, whether through the informal or formal process, and they publish it in the Federal Register, they then always hold hearings, and those hearings are held at a minimum of each of their regional areas. So they have 10 regions, and in some cases where the regions cover a large geographic area, they may have multiple hearings within that region. And then all of those transcripts from those hearings where people are arguing for or against, people are putting in data, that type of thing, and any of the responses made by EPA personnel during those hearings are then put online. There is a comment period before the final rule goes to the Federal Register for printing. And again, it is a long, laborious process and very costly for everyone involved, and it still doesn't preclude the lawsuits happening after the fact. There are some limitations on administrative agencies. Primarily, there are statutory and institutional. Statutory limitations is the Administrative Procedures Act mandates public involvement requirements. So those are specific laws that say where and how and for how long the public has to be involved in rulemaking. The Freedom of Information Act allows civilians to write into the particular agency and ask for written information. It might be documentation, it might be letters, it might be laboratory analysis regarding a specific rule or regulation, or even regarding the enforcement and compliance of a specific company. And only trade secrets or protected trade secrets for that company will have to be excluded, and the government is required to provide that written information to the person requesting it. And the Government and Sunshine Act involves that certain meetings within an agency must be made public, and the public must be allowed to be involved. The institutional limitations come through the executive branch, the legislative branch, and the judicial branch. For example, the executive branch limits the power of administrative agencies. First, because the president appoints the heads of all of these agencies, so obviously he can somewhat control what those agencies do or don't do through appointing that head. And again, the heads of these agencies change every time the president changes, or if they decide to resign during the course of the president's term of office, or if the president asks them to step down. The power of the Office of Management and Budget to recommend a fiscal year budget for each agency. So one way they can limit an administrative agency's power and control and ability is to reduce their budget. So if they're wanting to do something and the president doesn't want them to do that, then they can cut that budget line item so the agency doesn't have the money to operate in that area. And also the power of the president to issue executive orders, which can limit the rules that the administrative agency might be enforcing. The legislative branch has wide authority, basically because it passes the laws which the administrative agencies handle, and their authority for oversight includes their authority that limits administrative agencies' power is oversight, investigative, the power to terminate an agency or amend its enabling statute, the power to approve or disapprove budgets, the power to advise and consent on the president's nomination for heads of administrative agencies. So once the president appoints who he or she wants to be head of an agency, then the Senate has to approve them. But a rarely used power is the 1996 Congressional Review Act, which can overturn an administrative regulation within 60 days of its promulgation. This rarely happens, but they do have the power to do that. And the judicial branch can curb excesses of the administrative agency's rulemaking and adjudication functions by reversing or modifying such actions, such as an interpretation of a statute, regulation that the agency has set forth. These are a couple of the cases that are involved, which we will not look at this point. So let's look at some of the important agencies affecting the environment. We have executive versus independent agencies, we have hybrid agencies, and we have interagency cooperation. So first, one of the agencies that we will look at more closely than any others is the EPA. As stated earlier, the EPA was created in 1970 by executive order by President Richard Nixon. Its purpose was to protect human health and the environment by writing, implementing, and enforcing regulations based on laws passed by Congress. It has its headquarters in D.C. It is headed by a cabinet-level administrator appointed by the President and approved by the Senate, and it's divided itself into 10 regions, and it has 27 labs across the country. This essentially is how the regions are divided, and you can look at them more closely. And the example I gave you earlier is, or that I will talk about in just a moment, we currently live in Region 4, which covers all of this blue area right here. And I'm actually meeting at EPA headquarters on Tuesday. Not EPA headquarters, I'm sorry, EPA regional offices in Atlanta on Tuesday, and I'll talk about that in just a moment. Other agencies that deal with environmental areas, which also includes wildlife and like wetlands protection, things like that, is the Department of Interior, the Department of Labor through the Occupational Safety and Health Administration, the Department of Agriculture, and the Department of Transportation. The Department of Interior, their Bureau of Land Management, National Park Service, and U.S. Fish and Wildlife Service deal specifically with environmental species, habitats, that type of issue. The Department of Agriculture through the Forest Service, the Department of Labor through the Occupational Health and Safety and the Mine Health and Safety Administration. And as a corporate environmental attorney, my work involves permitting, compliance, and training. I work with companies across the United States, and occasionally they do get into trouble with the EPA and other agencies, and the process involves the spectrum of changing practices and procedures to meet the requirements, negotiation, and settlement hearings. Next week, as I previously mentioned, I will be meeting at EPA's Region 4 offices in Atlanta with one of my clients to begin the process of negotiation and settlement for violations related to disposal of regulated waste streams that were not done in a timely manner. I serve as the buffer between the client and the EPA while trying to negotiate a fair and reduced fine for the violations. At some point, if we cannot agree with the EPA Office of Compliance and Enforcement, the client has the right to appeal the decision to an administrative law judge, and after that, if they're still not happy with the resolution, they can appeal to the Circuit Court of Appeals in the area where the facility sits, which in this case happens to be Tennessee. And we will look more closely at this process as the summer goes on. And that concludes the Module 1. Thank you for listening.